don't have that option. Let me just check.
All right, so we'll start. All right, so hello and very good evening. We welcome you once again to Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the generous contribution of our seniors, guides, and mentors. Today we have the privilege and the opportunity of learning from yet another legal luminary, Shri Ranji Thomas sir. So we welcome you. And to introduce Ranji sir, today we have Mr. Sarthak Mago, an advocate from Delhi. And Sarthak ji, I request you to kindly introduce sir.
Thank you for giving me that opportunity, sir. Mr. Ranji Thomas is a distinguished lawyer practicing in the Supreme Court of India and other courts since 1985, a graduate in commerce and law, bachelor's in commerce and LLB. He has built a stellar career spanning litigation, advisory roles, and public service. He has served as Advocate General for Arunachal Pradesh from 2014 to 2016, Additional Advocate General for Haryana in the Supreme Court, and a Senior Executive Member of the Supreme Court Bar Association from 2022 to 2024. His long-standing association with the All India Congress Committee includes serving as Secretary of the Legal and Human Rights Department from 1992 to 2007, and as a Secretary from 2004 to 2012, where he oversaw major party forums such as the AICC sessions, the CWC and CEC, and held charge of Bihar, Manipur, and Nagaland. Before the courtroom, Mr. Thomas has contributed significantly to governance and community initiatives as non-official director for National Minorities Development Finance Corporation, chairman of the Swami Shraddhanand College, Delhi, the vice president of the National Consumer Disputes Redressal Commission Bar Association, and with over 3 decades of experience, Mr. Thomas is recognized for his expertise in law, socio-political engagement, and institutional leadership. We welcome you, sir.
Very warm welcome to you, sir. Thank you, Sarthak ji.
Yeah.
Ranji sir, we're very, very grateful to you for taking this time out. And sir, we request you to kindly enlighten us on this very unique topic of public interest litigation.
Thank you. First of all, I express my heartfelt thanks to you for making me a part of your team and to share my understanding and experience in the field of public interest litigation. I would like to start about the beginning of the public interest litigation. Even in our constitution, the preamble of the constitution says that it's a socialist secular country, and ultimately our aim is to give the maximum freedom, benefit, protection, safeguard to the citizens of all kind of categories, from the richest man to the poorest man. But the point is, how many poor people are able to get the real benefits? Am I audible?
Yes, sir, you are.
Yeah. How many poor people are able to get the real benefits or the proper administration or the safeguard? And how can they achieve it? So, therefore, seeking social change through judicial platforms and a litigation for the helpless or voiceless citizens are the public interest litigations. The origin of the public interest litigation, normally people think that started from United States of America. But in my understanding, if you see that one of our great legal luminary, one of the most adorned Judge of Allahabad High Court, Justice Anand Narayan Mullah, who was a leading criminal lawyer thereafter in the Supreme Court, who lived up to 95, 96 years. There is one judgment of him, which was in 1962. We can also see it in Criminal Law Journal 125 of 1962. The state versus Muhammad Naim. That is the case. That is the first case where the sitting judge was categorically making a clear direction to the police and exposing the misdeeds of the police officers who are fabricating the documents, who are doing all those things which they are not supposed to do. In this particular case of Muhammad Naim, the court found that he has fabricated documents and he has put the person into difficulty while handling the case. And the Honorable Court, Justice Mullah, in his judgment has punished him and made it very clear that his behavior was absolutely unwanted, and this is not how the police officers are supposed to behave. Ultimately, he has pardoned him, but the state police, the state government has come, it is anti-public interest. They came to the Honorable Court and asked for expunging those observations made by the court and directions given to the police department to act properly. If you go through that judgment, you will find what a marvelous judgment it is. And it says that the responsibility of the state is to protect and safeguard the interest of the citizens and not to protect the interest of the officers who are doing wrong things. Whereas in that particular case, the government of Uttar Pradesh has approached the court in support of the officers, not in support of the general public who are supposed to be benefited. So if you go through that judgment, you will find that how beautifully that judgment is written, and that judgment touches to the heart of every sensible person who understands how a democratic setup on a executive or bureaucracy has to function. If you see, the next case is that about Justice V.R. Krishnaiyer. Justice Krishnaiyer is another judge who always were equal to or even more than that to the British and US judges, which the whole world has accepted him into that way. If you, some of them may be recollecting, there was a case of Sunil Batra and Charles Shobraj, who was a Nepali citizen who was arrested and put in the Tihar jail. So these two persons they approached the High Court, but the High Court did not appreciate them. Ultimately, they had to approach the Supreme Court under Article 32. So another letter was given. Through the letter by Sunil Batra, the Supreme Court has made it very clear that how the reforms are not what is happening in the world is not going to the prisons, and how the prisoners or under trial people are dealt with in inhuman manner. There was no human rights given to the prisoners, or especially those who are convicted or sentenced for death penalty or life imprisonment. I think our friend Keshav Sharma also filed one petition in the High Court for the jail reforms, which I appreciate him. So then that judgment, Justice Krishna Iyer and Justice Honorable Chief Justice Chandrachud and others, they have made it very clear that the prisoners are also human beings, and you cannot behave with them in any inhuman manner, and they also have fundamental rights. Of course, unfortunately, rightly or wrongly, they have committed a wrong, or even otherwise they are convicted and in the jail. That doesn't mean that you can chain them and put them in solitary confinement and you cannot allow them to live a life, even that of other prisoners. So that was another stepping stone for opening the eyes of the administration. Thereafter, the other famous one, Husainara cartoons case came, where a large number of under trial prisoners were kept without trial, and even many years more than their sentence. And the Supreme Court, Justice Bhagavati at the time, who was one of the champion of the public interest litigation in the country, headed the bench and made the eye-opening judgment, which helped all under trial prisoners all over the country. Similarly, at that time itself, there was one case which I remember, which I also happened to associate with my senior advocate at the time, Mr. Muralidhar Bhandare, who appeared in that matter. That was the Dharwad in Karnataka municipality employees. They were all made contract basis, and it was the practice in every municipality. They were appointing people for work on contract basis. And the Supreme Court said that, well, it is the duty of the responsibility of the state or local government, whosoever it may be, to ensure that if they have worked for more than specific years, they should be considered as an employee of the municipality or local government or whatsoever it may be, and they should be paid salary and they should be confirmed. That has also helped around 50,000 ad hoc or contract employees, which was another marvelous judgment which has given a social upliftment to the poor and downtrodden people. Now, thereafter, I can speak about myself, where Justice Ranganath Mishra and Venkatachalaya, and that was probably the first year of my entering the bar, and there was a eye operation camp in Uttar Pradesh, Urja and Muradabad, where 89 patients were operated for cataract and eye problems in Khurja, and 84 of them lost their sight. That was something which is really shocking. So one day, one of my acquaintance, one A.S. Mittal, came to me with some newspaper cuttings and all, and said, "Sir, this is what happened. It is scorching heat, 44 degree, and this all happened. These people lost the sight. Can we do anything for them?" Then I immediately thought that let me try the weapon of public interest litigation, which can help those people. So I filed the petition. Matter came up before Justice Srinath Mishra and Justice Venkatachalaya. Then they were both were the judges. Subsequently, they have become chief justices. So while the matter was heard, the honorable judges asked Mr. Counsel, we appreciate your spirit, but see the operation, the program was conducted by Rotary Club, is a private organization, not a government. Similarly, the doctor who operated also is not a government doctor, it's a private doctor from Jaipur, Dr. Sahai. So how can you file a writ petition against individual or private parties who are not the government, which will come under Article 12? So I said, therefore, you go and file some suit. That's all what you can do. Then I have closed my file and I told the honorable judges, look, we are in a democratic country where every government's responsibility is welfare of the state and protection and safeguard the citizens. So if the government cannot protect the citizens, then the protection will be given by whom? So the people will have to take law and order into their hands, or will they go and face them? That's not. A welfare government means everything what is happening in the country or the state or their jurisdictional area, it is the responsibility of the state. And that was the time when the extremism was there in Punjab. So one of the bus which was going to Punjab was stopped by the terrorists, and the people were brought down and they were killed. So I brought this to the notice of the honorable judges and said, look, if this type of thinking we are having, somebody can say that the terrorists are no private terrorists, they are not government terrorists, or the bus which they were traveling was private bus. So therefore you cannot see that but it is the ultimate duty that medical superintendent of the district was supposed to give a certificate. If he has given the certificate, he himself is sufficient as the state. So the judges were overwhelmed by that and they took back the file, said, yes, young man, we appreciate what you said and that is the right way. We are issuing notice and giving 5,000 rupees immediately within a week's time to give to all of them. And we will also add Medical Council of India as party and Union of India as party, and we'll have a proper guideline for the whole country for the eye operation camp hereafter. The matter subsequently came after 1989, and then they have further increased the amount. And by the time a proper guideline was prepared by Medical Council, and also the court has allowed the parties, they have set the limitation for filing individual suits for damages were further extended, and the state government was asked to give them the lawyers from the legal aid or whatever government has to take over those things and do private suits where for damages has to be done. So that was another case which I can be very happily part of that, because I was the one who argued that matter. Then again, if you see that Vinith Narayan's case is another thing with Hawala, the political personalities who are owning the positions in the country thinks that there is nobody above them, and the corruption is the root of every disease in the country. So in that particular case, Mr. Vinith Narayan who brought, and Mr. Senior Advocate Mr. Anil Diwan, they have worked so hard that ultimately Honorable Justice J.S. Verma has made it very clearly that was the beginning of political warning to the politicians how to behave, and there is no license for corruption. There is no license for misbehavior in public life. So again, you will see SP Gupta's case, in which now the collegium system shattered. Then Bandhav Mukti Morcha case, you know that. Then another case was Parmanand Khatara, who was also a lawyer in Supreme Court. Most of the time, what happens when people travel, or some accident take place, or something happens, or even some fights take place, and the patients are taken to the hospital, and the hospital people used to say that this is a police case. Therefore, you go to the government hospital or get a police certificate. There only we can do that. And that in the meantime, many people used to die. By filing this petition, he has brought to the notice of the court, and the Honorable Supreme Court has directed that henceforth, any patient is brought to the hospital, it is the duty of the doctor, irrespective of it is a criminal case or normal case, to attend to the patient and do that. So that is another case which was done. Now again, I am once again happy to say that I myself, in my own name, Ranji Thomas versus Union of India, when the change of government took place in 1990, the new government under Vishwanath Pratap Singh ji came, and the first thing what they did was removing the governors appointed by the previous government. 22 governors were removed at a time. The reason was the pleasure of the president. The pleasure of the president, I argued in the Honorable Court. Justice, the matter was referred to the Constitution bench. Then subsequently it came up before the Constitution bench, where Dr. A.S. Anand and other honorable judges were there, and Mr. Soli Sorabji, who was the then Attorney General, appeared against me. So I have said the pleasure of the president doesn't mean that anybody for any reason can have displeasure. It has to be a reason, proper reason, constitutional validity of that. So merely the pleasure of the president means 22, one person, yes, there can be pleasure. If there is some misbehavior, misconduct, yes, you can change the governor. But 22 governors. Then Mr. Surabji opposed, saying that I don't have a locus. An individual cannot come to the court. He is not a governor. He is nobody. How can Ranji Thomas file a petition? But the Honorable Court made it very clear that any law-abiding citizen who is interested in the country's governance can approach the court for constitutional violations, and the locus standi was made clear for a citizen, and I was in that part, I was succeeded, and by the time it took 10 years, and the governors who were appointed, either they were no more or they retired long back. So thereafter, on merit of the case, there was nothing, and therefore they had to dispose the matter, allowing the locus and the other part in some other case in future. Thereafter, VP Singhal, when the next government came, VP Singhal filed a similar petition in which there are 3 or 4 governors were removed by the subsequent Congress government. Mr. Vahanavadi was the Attorney General at the time. Accidentally, Mr. Soli Sorabji, or incidentally, he argued for VP Singhal, and he adopted all the arguments I have taken on the other day. And Mr. Vahanavadi opposed, and he adopted the arguments of Soli Sorabji as the Attorney General. Ultimately, the court has held it properly in continuation to my case in that. Now, MC Mehta is another person who has done a great service to the nation by continuously doing the petitions. He has filed a large number of PILs, and everything is MC Mehta versus Union of India, MC Mehta, starting from Ganga cleaning to environmental protection, from Himachal Pradesh, the resorts which were made, and now the environmental protection. Now you see the way the rain is happening, the catastrophes are taking place. So even Uttaranchal, Himachal, we are all to an extent, and pollution in Delhi was controlled by that petition, his effort. Even the building, a large number of residences were misused by unscrupulous people, businessmen, property dealers, and land brokers with the connivance of the MCD and police officers. And Justice Sabarwal made it very, very clear that no residential area can be misused for any other purpose and create hardship for the people who are residing, lawful citizen, because there is no place for them to go. Police is not protecting them, MCD is not protecting, DDA is not protecting. Where the common man will go? And the system is so bad that no one get any relief from them. So the court has made it very clear that wherever such atrocities have taken place, wherever such indiscipline, the court automatically will come into the help of the ordinary person and help them. Now, another important case is Vishaka's case. The women of this country, the working women of this country is largely benefited by that. The gender injustice, the domination, the bossism, the misuse of the office, everything was streamlined, and that was a new beginning of gender justice and the rights of the women in this country. Now, Prakash Singh's case is another case where the police asked, if you go back to the 1962 judgment of Justice Anand Mullah, the governments never bothered to look into Justice Anand Mullah's judgment. They have never bothered to improve the police system. The police people have become only the tools in the hands of corruption or the political bosses. And the common man, if they approach the police station, the police never bothers. They don't file an FIR. They don't do anything. Even they attack the people who go there for relief. That was the stage in many police stations. I'm not saying on all the police stations that was the thing. And the appointment of Director General of Police and other senior officers, CBI director, all those things were whims and fancies of the political bosses. So in Prakash Singh's case, the Supreme Court said the tenure of the head of the police department, whether it is CBI or the Director General of Police of the states or other serious police organizations, has to be done properly. Now it is streamlined to a greater extent. And subsequent to that, Justice Wrongton Nariman also in Saini's case said that all the police stations should have cameras, because when a poor person come, the police don't take care of them, don't bother about them. A person has to go 10 times to the police station, 20 times to the police station, and there is nobody to attend. There is no receptionist in the police station. There is no reception in the police station. Nobody will answer to a poor person. As lawyers, when we go with a coat and gown or a band, of course, the police bother. Otherwise, for a common man, except there is a rich man who is affluential, they don't bother. So, Justice Wrongton Nariman's judgment very clearly says that to see that everyone is treated properly, all the police stations should have cameras, video cameras, and record all this, especially a woman or any person with disabilities come, even the filing of the complaint to every proceeding has to be recorded. Now, recently in the Supreme Court, Honorable Supreme Court has passed even that order of Justice Wrongton Nariman few years back is not followed by many of the police stations. There is no cameras in the police station. The Supreme Court orders are not properly being implemented under Article 142, every citizen of the country, including the officers to the Prime Minister, to the President, everyone is bound by the order of the Supreme Court. But unfortunately, many people, many organizations, many bureaucratic setups are not giving importance to the orders of the Honorable Supreme Court. So court has to again remind that you have to implement the orders of the Supreme Court. Now coming to the other aspects, many of you are aspiring lawyers who are going to be great lawyers in the coming years. So you have to understand one thing. Public interest litigation is a weapon given to each one of you as a social leader. Every lawyer is a leader in himself. Every lawyer is a social reformist. The mere purpose of a lawyer is not to make money by legal profession, but a lawyer is the natural leader of the society, and any atrocity, any action by the bureaucrats or anyone who is instrumental in not following the rule of law, it is for the lawyers, not only that their own clients, but as a leader of the society has to take up the causes, and you should all venture. And tomorrow, each one of you, every day you can see so many things happening in the society, because nowadays what is happening is, instead of improving, things are going bad to worst. I am not saying about the countries neighboring India, but even see shockingly why it is happening in Nepal or Bangladesh. The people are disillusioned by the political setup and leadership and the bureaucrats. Those who are supposed to protect the people, they are opposite. They are rather instead protecting the criminals and protecting the rich. Just see how the society will be run by people who are only one-sided. Father of the nation said, unless the tears of the poorest among the poor person is wiped, we really don't achieve the democracy or the freedom which we have got in 1947. So it is your duty and my duty, as long as we are alive. Like Swami Vivekananda said, we have come to this world before we disappear from this world. It is our responsibility to do what we can do to the society. These are all as a lawyers we can do, because what we have a great advantage is that a lawyer means you are leader and everyone respect you, including the police officers or bureaucrats. If an ordinary man goes, they don't respond. When a lawyer goes, they respond. And we can easily find out what is happening, and we can take the cause. If the government is not, or the concerned authorities are not responding, the courts are there, and the public interest litigation has come to that level today that many of the high courts are equally important, like Supreme Court, taking care of the poor and ordinary citizens. And public interest litigation has become a great shield and great weapon for social justice and benefit for the public. Now, the Honorable Court many times said, when public interest litigations were brought, that court cannot shut court's doors to the poor and oppressed, and court cannot keep therefore always for the rich and who can be affluent and rich. To conduct a case in the Supreme Court is not an ordinary situation today. Only rich people can know the backlog of cases also. It's very difficult for a poor man to get a case listed itself now. Now, Honorable the Chief Justice recently has made very clear categorical statements on various aspects, which are all to be followed by every lawyer, so that the sanctity of the Constitution, there is no one who is above the law, no one who is above the Constitution. There is, I will just finish in 2 minutes time, you can ask question thereafter, Mr. Pranay. So, the Constitution is supreme, and the executive, judiciary, and legislature has to have harmoniously, constructively work together, so that ultimate goal is the poor man, the citizen, the law-abiding citizen has to be taken care. So under these circumstances, we as a lawyer community, we have a great responsibility on us to do the best what we can do without expecting, like karmanye vadigarisya ma phaleshu katachana. Before thinking what benefit we are going to get personally, there are lawyers today, we can find competition between lawyers that how much more money they can get it. That should not be the aim for every lawyer. How much we can contribute to the society, that is most important. So that we can do, one of the greatest way of contributing to the society is public interest litigation. Each one of you should select one item, and which you should do research properly, approach the authorities. If they are not following, then you should go to the court and get it done. Thank you so much. Anybody can ask question. You can ask me anything, which anything more you want me to say, I can, my understanding. Keshavji.
So thank you so much. It's been absolutely fantastic, sir, hearing. First of all, you so eloquently elaborated the illustrious history of the public interest litigation, along with all the honorable judges who have shaped up the entire law and jurisprudence today in India. So, I have a lot of questions, of course, myself, but there are a lot of questions which other people also have. So, we'll take up questions now. I'll ask my ones at the very last. So, first, I'll start with Nayak sir's questions. So, we are at the Supreme Court Library right now. So, sir, please.
I request you to speak a little loudly because there is some hearing problem for me.
No,
Yeah.
but we'll try to be louder.
Sir, most of the lectures given by the judges or the advocates are only theoretical and history. We have to go by the working knowledge. Now, some days back, I filed a public interest litigation that is most important. The crux of the matter was in every village, a big office complex has to be open for a village accountant, postman, watchman, every sector. Because the government say go and work for the in the village, there is no office at all. Money, 1,000 crores of money sanctioning by the in the name of the village also. Everybody was saying it is most important, highly required, because many people, those who are outside, they have lost their properties. There is no office, they cannot manage at all. Suppose you go to the village account, any office, there is no parking, nothing at all. House is a privacy. Those are working in the toilet room or the cattle shed, etc. But the Supreme Court dismissed the public interest litigation because the Supreme Court, Parliament, Executive Committee, whatever else, whichever the essentiality required to the nation, they must execute. It is not my job. This that happens because such a things happen. One day, the like a Nepal happens. So, what is the current? We have to understand the current knowledge, progressive knowledge, working knowledge. Only saying here, most of the lectures are only maintaining dignity status, never touching the problems of the current knowledge. You know very well, it is highly connecting. Appointment of judges, their own kith and kins, they are not finding out a first generation competency. You so kindly speak about the practical knowledge. Juniors are getting the seniorship with the chamber. Most of the seniors are getting done the work by the first standard or second standard, third class. They keep the 45 or 14 getting done the work like a slaver and only saying American jurisprudence and law, common law of England. There is no use at all. Why the children are coming out for the, what is the use of the school college? Let them close the law colleges. Every day the juniors are asking, we are not getting the officers.
Sir, may I reply to you?
Okay, please, sir, please.
Sir, my understanding, they don't think that I am also a person who knows everything. Okay. Okay. I understand from my practical experience and life, and I am not a son of a big lawyer or any lawyer. I am a first time lawyer, and I am from a village, and I am a son of a farmer. So I also have come to this court like any other normal person without much support. And I have suffered what all things you are telling, I also suffered in my life. But what I am suggesting to you is that what you have done, one mistake is coming to Supreme Court is one mistake. Number two, you have mixed up so many things in one petition, because you see so many officers, with some of the officers are under local government, some of the officers are under the state government, some of the officers are at the central government. So you have clubbed everything together in one petition and came to the Supreme Court and asking Supreme Court, which you cannot identify. What rather you could do is that in the village, there are not other many offices in the village. In the village, either panchayat or municipality or block panchayat or gram panchayat office will be there, post office will be there. So these are all the places which are available there, and post office is under central government, it is different. The village panchayat, so there are so many things where you are, and there are court premises, it is under state government. So what you did is that you have not done proper research on which all things come under one particular department or a government. So then you are coming to Supreme Court and asking in general. When we file a public interest litigation, what you have to understand is that you have to do a lot of research. And you have to be very, very specific in what you are doing in a particular place, in a particular location, which under which governance, whether it is a local government, because local government and the state government is different. It's a part-time, it is a different central government, state government, municipality, block panchayat, jilla panchayat, then gram panchayat. So these are all under different departments. So and different authorities. So you have to see, and junior, senior advocate, it's all different category. So if you have clubbed everything, court will not be able to give. You have to do a different thing in that, understand it in a different manner. The High Court was the right place. You are from Andhra Pradesh. Which state you are from?
I belong to Karnataka. I made a state government and central government equally. Now the constitutional.
No, you are from which state? You are from which state?
Karwar.
Karnataka, you are supposed to go to Karnataka High Court first with the public interest litigation. If first of all, sir, just let me complete. First of all, you are supposed to give to government. Suppose if there is any deficiency in a particular place in the panchayat office, there is a problem. You should ask meet the secretary of the panchayat and tell them, and or thereafter the minister in charge of the panchayat department of the state.
It is only for 50 villages or 48 villages. Gram Panchayat is not in every village function. Nowadays, what constitutional bench matter is going on? What the president asked? President asked why Supreme Court pronouncement of the judgments are getting so prolonged. Where is the answer?
Sir, these are all different. These are all different. That's a constitutional issue. That's what I said. You have clubbed so many things together. You have clubbed up everything in one petition. Please do different petitions.
My petition very meticulous, because 2005, 2008 I filed the public interest litigation. Now I am getting the relief. I submitted the petition, rural development minister and honorable prime minister. Everybody are up.
Prime minister and all, you should not go to the local only, Karnataka government only. You have to. What you do, if you are in Delhi, you please meet me. I will try to talk to you separately. We don't have to talk too much without your petition. And if you are coming to Delhi, you can meet. Otherwise, you can send it to me by mail also. I can see. We'll discuss separately. Okay. Thank you.
So absolutely, sir. It was a very enlightening conversation this between both of you. And so, sir, but it brings me to one very important question. That's what would be the 5 do's and don'ts that you will suggest to all lawyers? 5 do's and don'ts that you will suggest to all lawyers before filing a public interest litigation.
Before filing a public interest litigation, the most important task, you have more responsibility than the judges. You have to do research work. You have to do whether any case of similar nature was done by the Supreme Court or any High Court in the country, or even the country, even the Supreme Court of any other country also, so that it will be more and more helpful to you now as far as, for example, the jail reforms are concerned. You have done a very marvelous work of filing a jail reforms petition, Mr. Keshavji. But
Sir.
when we see that similar attempts were made by other people also earlier, so all the things what we can do is that we know that then in continuation of that and reference to that, we can very easily do it that the judges, because many of the High Court judges may not be aware, because High Court judges are also not reading all the judgments. They are not, unless we point out to them, they will not be seeing that also. So therefore, hard work on that, both facts of the case, like our friend who was telling just now, he has taken up many causes in one petition, which cannot be entertained by the court, because it is all different authorities. So you have to meticulously see that only one point and one authority is involved in that when you are taking up a particular aspect. Otherwise, it will be messed up everything, and the court will not be able to do anything in that matter.
The courts are passing by looking the face, and in many matters, my learned junior worked very hard. 2 crore rupees fees to be given. What is this? Karnataka High Court issued the notice, 73 lakh rupees give it to the Advocate General. Whether it has passed the order, the several advocates, those who are working for the bread of their mother and father, whether the court pass such order?
Sir, unless I see your petition, I cannot say. I told you we can talk separately about your case. You can show it to me. We'll discuss that separately. Thank you, sir. On that point, I am not clear. I have not seen your petition. You may be right. But once I go through, I can further support you in that. Okay?
So certainly, sir. I will definitely try
in
to
this
arrange.
country, many attorney general, even they cannot speak the Hindi. They are in the highest post. My life is for the nation.
No, Nayak sir, I request you also, sir, for that matter of fact.
Many communities never give
sir,
Solicitor General, Additional Solicitor General. 79 years over. These people are black men into the country. Where the purpose is required.
Sir, we will talk individually. Sir, you send me the papers, we'll talk individually. Okay? Thank you.
Definitely. But in the interest of, there are other questions also today that we will hopefully.
80% of the Supreme Court judgments never implemented.
So there was a question from Mr. Pranay, I think, wanted to ask a question. Pranay ji?
Yes. Good evening, sir.
Please,
First of all, thank you so much for conducting the seminar. I'm a final year student from ILS Law College, Pune. I have a small question to ask, sir. That what do you think when courts admit these PILs on trivial issues? So isn't it the real public interest in speedy justice getting quietly sidelined? Like the more important issues are to be, addressed first. But we often see that public interest litigation has become more of a publicity interest litigation. So what are your thoughts about it?
Yes, Pranayji, I 100% agree with you. And I personally am aware, because when you are, I was also Advocate General. You have said about earlier when you introduced me about, you are seen from my old internet thing, I think you are collected. I was also Advocate General of Arunachal Pradesh. So I happen to come across a large number of cases, not only there, but being in Supreme Court also, and seeing the public interest litigations which are filed. My friend, you said just now, is 100% right. Now, 75% of the cases are not real public interest litigations. And most of them are publicity interested, because many lawyers want to get publicity by filing public interest litigation without proper study, proper understanding, proper knowledge, and proper causes. Merely for some or other reason they file it. Then another is publicity interest, then political interest litigation. There are political people. There are some people in the Supreme Court and High Courts continuously going in favor of a political party, whichever party they are. They want to get benefit out of the political party, or they want to be known as that political party. So they do political interest cases against the persons. And there are also cases which are done by business houses, industrial houses. if suppose there are some particular rival parties coming to a place doing some work, then they set up some people to go and file public interest litigation and to stop the working. Now, in Mehta Padkar's case, one case which I remember, which I was in the courtroom, that was must be 1989 or 90, I think. She is, of course, I have no doubt about her genuineness and her public spirit. She is one of the best fighter and a real public interested person. But problem is that when we think that we are the only persons who are doing that, others are not doing, then we get into a track. Saying our ego problem comes in between. So what she had, that problem. In that also, I was happened to be in the courtroom. Matter was going on, and I think it was Justice Kuldeep Singh who was hearing the matter. So suddenly she was getting agitated in the court and said that, well, you should see that, you should see that, all sort of things. Then the court was trying to make her understand, don't be overexcited, don't do like that, be cool down. But ultimately she did not. Then the court said that, we are very sorry, we are discharging you from the case, but we will continue with the case without you. So that is another way of Supreme Court or any court, High Court also, doing the public interest litigations. If there is a real genuine cause, even if the person who is doing it is either under somebody's patronage or misusing it or overdoing it, the court can always discharge them and continue with the public interest. So then we will be out from the court. So that is there. So what all you said is correct. And that is why recently you will also see in the Honorable Supreme Court also, some of the high courts also has imposed heavy cost on some of the so-called public interest litigations, which are only for the sake of publicity or setup cases. So in some cases, I think in one case, 10 lakh rupees was also cost was imposed. And many cases, 1 lakh rupees cost imposed. So the courts are also equally aware. The judges are also equally aware of what is happening. We are only talking about our own case, but the judges are sitting there. They are seeing so many cases. In the Supreme Court, for example, one judge on Monday and Friday see 70 to 75 cases one day, they read and come. So they know before we are arguing our case, before we stand up, they know what is the case and why we are doing the case, what is the purpose. So we have to understand that we cannot fool others and we cannot fool the judges. If we are trying to do that, we will be fooled. So anybody doing political interest, private interest, publicity interest, they should know that. And of course, that is wastage of time. We should never do that. Any one of the party who is involved in this particular discussion today, you should be very clear about what you are going to do so that you should do it. Of course, there has to be some publicity. You will get publicity. You cannot say that you will not get publicity, but it has to be in the proper manner after due research, and don't be succumb to somebody else's pressure. That's it. Something happened? What happened? Can you see me or not? Can you hear me?
Yes, we can see you, sir, but I think.
Yeah, please continue.
Sir, I just have a small follow-up question to whatever you said. Do you think there should be a mechanism to hold petitioners accountable for frivolous PILs? Maybe something like a PIL audit, or would that defeat the very purpose of keeping the doors open to PILs?
Of course, that is what I said. The courts can impose cost, heavy cost, small cost, high cost, anything. You see, if you are trying to do something, if it's a real thing, there will be no cost. There are some people who, you see the list of, there are in one or two, I was in the courtroom again, in one or two cases when the matter, the one person was arguing his public interest litigation. The Honorable Judge asked Mr. Counsel, how many public interest litigations you have filed this month? This man was trying to wait. Now the computer shows everything. He said you have filed 11 PIL in this month itself. So the courts are aware. We think that we others do not know. But the court and the computer system, because the moment you file it, it will come. So these are all like what you can call the continuous proclaimed offenders and habitual offenders, like habitual public interest litigants are also there. So
Certainly.
what you said is already aware of the court and they are taking steps on that.
Thank you so much,
Thank you so
Pranay,
much
for
for the answer.
Yes.
Thank you so much.
wonderful answer, sir. Thank you so much. So there is a question from Mr. Sarthak and one from Mr. Karthikeya. So we'll
Can you
just take.
please little more louder?
So there is one question from Mr. Sarthak and one question from Mr. Pranay. So if you'll
Please.
permit, one from Mr. Sarthak and one from Mr. Karthikeya.
Fine,
So
fine.
if you take these two questions now. So Sarthak ji,
Please,
please go
sir.
ahead.
Thank you, Keshav. Thank you, Mr. Thomas, first of all. So I predominantly practice in jail reforms in the High Court. We represent a number of convicts.
Little more louder, please. I cannot hear you properly. Huh?
Can you hear me now, sir?
Yeah.
Yes. So I work in the Delhi High Court, largely representing prisoners on human rights concerns in the Tihar jail, sir. So there is a growing tendency within the High Court to dispose of petitions filed by the prisoners by saying that the government may treat it as a representation. Now, when a prisoner approaches a court, he has already exhausted, waited a substantial amount of time for his petition to come to court, finally afforded in some way to bring it to the court through a lawyer, and then it gets disposed of. He has to wait another few months for the state to make a decision. This is also predominantly a practice in terms of premature release petitions, because that is somehow considered a sanctimonious right of the state, that it's a crown function to grant remission. In a scenario like this, when multiple petitions have to be filed by people who can't even afford one, what would be your view? How could practitioners as well as convicts deal with a situation like this, especially when timelines cannot be prescribed to the government in law or otherwise?
Yeah, you see, I can also say the patience of the judges also. We have to be very careful about that. Now, many times what happens when the public interest litigations are filed, we unnecessarily waste the time of the court when more important work, because the judges are under full tension nowadays. The judges are always thinking that they have to dispose of the cases as early as possible. Because I can say, because we are a part of the justice delivery system. The bar and bench are equally responsible. It is not the judges alone. It is the lawyers also who are equally responsible. So the judges are now every day, the pendency of the cases are in the parliament. They are bringing it in the Supreme Court, in front of Supreme Court. They are showing how many cases are filed today, how many are disposed of, like that. So there is a tendency in some judges to dispose of the matter as early as possible. So if justice delayed is justice denied, and justice hurried is justice buried. So these are part of the thing. We have to be very careful, because judges also now, what happens now, there is a change of the attitude of the judges also now. I'm not saying any individual judges, collectively. What happened in the socialism? India was a socialist, and India is a socialist country even today. But unfortunately, the international happening in the arena of the system has made into a crony capitalism. We are coming to that level. If you see United States, what is happening? Business people are becoming the people who are running the countries nowadays. So what happened? Only their interest is ultimately is the business interest. So where are we going to end up with? It is the voters who will have to understand that when you are there, the Constitution of India is a sacred document, a divine document, which give protection to the poorest man, to the richest man. But if we remove the socialism from that, India will be worse than Nepal and Bangladesh, because the population of India is 145 crore people, and the rich people are not even 10% to 15%, and the middle income people are 45%, and the remaining 50% are below poverty or above poverty, or almost every poverty line. So what will happen to them? Now, see how much in income a villager is getting, 5,000 rupees or 10,000 rupees a day, a month. Are we thinking even the people even Supreme Court, some lawyers are getting 1 crore rupees a day? Just imagine how and from where it is happening. So mere the purpose of filing a public interest litigation, when you do a homework, whatever you said, you link it with other petitions, even if it is not filed by you, club it together. If a similar petition, 1 or 2 petitions are pending, clip it together. You do it together so that the time of the court is saved on that. And if the similar issues were discussed in previous judgments, bring it out, because judges are also not aware unless you show it to them. You don't expect the judges to read the judgments and come. It is our duty to read the judgment and show it to the judges. Then it will be faster. So if you take one PIL, argue 10 minutes time, the court will be happy. If you take it 1 hour and exceeding that, so many people are waiting. So we have to be careful. That's it.
Thank you, sir.
Thank you.
Thank you so much, sir. Thank you, Sarthak ji.
Karthikeya ji.
One question from Miss Priyadarshini. Priyadarshini, do you want to ask your question?
Sir, my question.
Yes, sir.
तो अच्छा कार्तिक जी आप पूछो पहले, फिर उसके बाद एक बार प्रदर्शनी
Yes, good evening, sir.
Good evening. Good evening. Good evening.
Yes, sir. No, sir.
You have to be a little more louder. I have to hear, sir.
Yes, sir. I am Karthik. Yes, sir. I am Karthik and practicing in the district court Kurukshetra, advocate practicing in district court Kurukshetra, sir. Sir, my question is now, what defines what defines a genuine PIL? What defines a genuine PIL, sir? My question is.
If you file a genuine PIL, definitely the court will entertain it.
What defines a genuine PIL? Sir, my question is this, sir.
Non-PIL, how can you file as PIL? See, there are different forms: civil court, criminal court, tribunals. See, if it is relating to that particular aspect, you have to go to that particular tribunal or court. But public interest litigation is one which is a common man, ordinary man cannot come alone and do it. For a community, for a society, for a people, or a cause as individual also. Like I filed the petition, pleasure of the president. It's a constitutional issue which was misused. So similar such situation will be genuine one which you can go, like eye operation cam. There are certain things where you would like that which people cannot come to individually, or you are there to help them as a lawyer. You are a leader, so you can bring it to the notice of the court, and it is a genuine issue. Definitely the courts will entertain it.
Yes, yes.
Thank you.
Thank you so much, sir. Thank you so much, sir.
Thank you, Karthik ji. Sir, last question. This is from Miss Priyadarshini Saini. Priyadarshini, please ask.
Good evening, sir.
Good evening. Good evening.
So my question is, what kind of evidence or documentation are typically required to support a PIL?
See, what type of document you see, many a times documents are not important in public interest litigations. The cause is more important in public interest litigation. If you are, for example, my own case, which I did it, both the cases, case Mittal, Kurja blinding case, I didn't have anything except the newspaper report, which was published in Kurja and Moradabad. I filed it, and I only tried to get the information that these where is the address of the people and what type of thing, and some photograph of the program. Similarly, in the other petition, constitutional issue, the pleasure of the president, there again I depended on the newspaper reports, and certain articles were written by eminent people. So these are the things. Public interest litigation does not need that, like in the civil cases you have to file certain documents, nothing like that. If you are a constructive person who are interested to contribute to the society and there is a cause, there you have to. There are reasons that you can get, like bonded labor case and child labor. They are admitted, they are doing. So there are something or other available, so you can get it. So what subject you are going to do, it depends on that, and there is no need of hard and fast that you have to provide particular document like that. It is your hard work. You have to do research. You have to take similar things from the, the internet, everything is available. Wherever, whichever court, you can find out. You can get a lot of things like that. You can supportive documents, you can get it. Constitution, judgment, and various documents you can collect from the net itself. I think that will be sufficient now. Is it okay?
Okay, so thank you.
Okay.
Thank
Yes,
you. Thank you
Keshavji.
Thank you so much, sir. Ranji sir, it's been absolutely, how do I say, it's been a thrilling session with you today, very enlightening, and I believe any person who has the opportunity of going through today's session will definitely have something better to say to court and possibly and hopefully contribute better towards the nation and country building. So, sir, we express our deepest gratitude to you, sir. And sir, we humbly request that, sir, since we've already taken more time of yours than we had requested, so, sir, I believe so. Questions are not ending actually. Mr. Pranay wants to ask another question. If you'll permit, sir, then that,
Yeah,
or
yes,
otherwise,
yes, no problem, no problem. You can continue. Yes.
sir, but this will
Yes,
be the
sir.
last.
Someone just
Please, please, please.
last question from what there was a against the misuse of PA.
I'm sorry, I
Would
can't
the
hear you.
court admit it?
Please
Pranay, voice.
repeat louder.
Sir, can you hear me now? Sir,
Yeah,
can you
please
hear me
Yes,
now?
go.
it's better.
Yes. So, sir, my question was, if there was a PIL against the misuse of PILs, would the court admit it?
No, you cannot have a PL against the misuse of PL, because that means you are, prejudiced against PILs. You see, each PIL, how can you predict that which PL is good, which PIL is bad? That means you are going against the spirit of the public interest litigation in total. So that itself will be thrown out before even you are arguing it.
Oh, all right. I mean, against it's a judicial discretion to decide whether the PIL is to be admitted or not. But
Sir, see, the PIL means what I told you. It is not a political interest, it's not a private interest. It is the court can make out. The moment you file a petition, they make out that what type of petition you are filing. So now, from all these great judges have given an opportunity for the poorest man to come to the court. The voice of the poor is heard by somebody who is interested in reforming and doing best. So you want to stop them? So it is,
no, definitely.
if you know that, my dear friend, if you know that a particular PIL is not correct, you go and intervene in that, implead in that petition. You can file an application in that particular PIL and say that, well, I am also a public spirited person and that person is doing in the behest of somebody else. So please dismiss it. You can say that. You cannot say that all PILs are wrong.
True, definitely.
Even I did that. I will not tell which case. There was one case in Delhi High Court, which was a very, very seriously contested case, and it was a case of national importance. At the moment, because of certain reasons, I am not taking the name. And the person who filed also is not an ordinary man. He was also an extraordinary man by brilliance, by political clout and influence, everything. And I intervened, again, myself intervened in the case and said, from where he is getting all these informations which he is doing, using in the court, which is not correct. Here purpose is to defame somebody else deliberately. So he is using the platform of the honorable court for his ultimate goal and game to defame and spoil the image of the other person. And the petition was dismissed. So you can do that.
So it's it's a really fantastic and wonderful so experience that we've had today of getting to learn from you on this. I think the last question from Pranay, I think we can possibly take it in lighter vein, say in the language of the court, because it was a very it's like a how do I say, it's like a paradox in itself, that question. But sir, deepest gratitude to you, sir, for so graciously, first of all, agreeing to take your time out and conduct this session with us, and for enlightening us, sir, so brilliantly, sir, with all the wisdom that you have showered upon us today, sir. Deepest gratitude to you, sir, on behalf of myself and all the participants and all the people who will be watching this here or later on YouTube as well.
Thank you so much, sir.
Thank you very much for all of you for your interest in the nation building. You are
Thank you
not
so much,
you are
sir,
not
for
you
wonderful
are not
class.
going to be a person of your personal choice. You are a person who is going to contribute a great strength to the nation, and you are going to be future leaders of the bar and the country. Thank you very much for inviting me and giving me an opportunity to talk to you. Thank you so much.
Thank you so much, sir. Thank
Yes.
So, yes, Jai Hind.
Thank
And
you.
also, in light of this wonderful session, which is a very public spirited session, I want to just put everyone and draw their attention back to one very important aspect of litigation, which is the fundamental rights that we have, which is with respect to free legal aid. So I request everyone that this we do out of whatever possibly we can with our own efforts, and it takes obviously it takes a lot of efforts on our side. But apart from that, also if you want free legal aid, please check out legal aid services. You have NALSA, you have in Delhi specifically. I'll just tell you that you have Delhi State Legal Services Authority. The numbers are 15100 and 1516. If anything at all, please just feel free to call them, reach out, and we hope that you will find wonderful people and wonderful solutions for yourself.
And one more thing, if any one of you need my help, always you are welcome. Okay.
you.
Absolutely.
Sure, sir.
That
Sure, sir. Thank you so much.
Okay.
so
All the best.
Thank you, sir.
in further,
Bye.
we will also ask you to guide us further on various other topics of law in the future as well. So we request that of you. So with that, sir, may I seek your permission to end the class today? All right. So, guys, thank you so much for being with us for this exceptional and wonderful class today. I express deepest gratitude to you. We are in season 5 of Vestralex free online community classes on law. This is your initiative, right? So, I know it's wonderful to see when everyone else is also contributing in this. I request that whatever, if you want to participate in the sense that you want to host classes, or if you want to, introduce guests, or you want to invite guests, please just feel free to reach out. At the same time, if you're watching this on YouTube, of course, after the session ends, at that point of time it will be there only. So please just like and share and subscribe. It takes a lot of effort to conduct every single one of these classes, and we do it absolutely, we try to do it in whatever better manner we can. So whatever your support is, it's only like this, and we're very grateful to you for that. So classes are Wednesdays and Saturdays till the end of November. So I request everyone to kindly, be here with us, and we'll see you regularly. Grateful to everyone who's joined and participated today. Thank you so much.
Thank you so much, sir. Thank you so much.
Thank you so much, sir.
Thank you. Thank you so much, everyone. Bye.
Bye.
Bye.